Hi everyone, Amber Carlson with Remax Elite. That guy is scary looking, but what's even scarier is somebody who has not planned with an estate planner about their living will or will and testament. I know it's a morbid topic and nobody wants to talk about it, but it is extremely important and it's something that should be discussed sooner than later or possibly before it's even too late. With that, I've asked Todd Scholler with Smith Scholler Milliken out of the Sumner County Real Estate Attorney's Office to just give us some tidbit information of how important it is for wills and estates to be in place, especially with the process of real estate. So let's hear what he has to say.
Hi, my name is Todd Scholler. I'm a licensed attorney in Tennessee, and my friend Amber Carlson asked me to speak to you a little bit about estate planning, some of the elements of estate planning, and some of the effects of failing to do that planning. I practice in the world of real estate quite often, and in many cases we have family members who have lost a loved one who need to sell property and experience difficulties doing that because the person who passed did not have an effective estate plan in place. An estate plan, generally speaking, would be comprised of a will, last will and testament, a living will, and a durable general power of attorney. Every state's different, every jurisdiction's a little bit different, so you really should talk to an attorney licensed in your area when you get ready to do your estate planning. Going online to do estate planning is not really advisable. We've seen some bad situations come up where people had documents that did not meet the requirements, so they weren't effective. But anyway, the last will and testament is the document where you determine where your assets go at such time as you pass. If you don't have that document, many states, all states have a law that tells who is entitled to your property, and that law may or may not be consistent with who you would like to have your property at such time as you pass. So the last will and testament is very important. It also allows you to specify, for example, if you have children, who you want to take care of the children and handle their financial affairs if you're unable to do that if you've passed. A durable general power of attorney allows you to appoint somebody to help you while you're alive with business decisions or healthcare decisions, that sort of thing. So that's also an element that you need to consider. Last but not least, there's a living will in many states that lets you predetermine how you want to be treated in the event you have a serious illness that you're not likely to recover from. You can decide how you wish to be treated or not treated at that point in time. So I would recommend highly that you speak to an attorney to avoid problems, to make sure your assets go where you want them to go at such time as you pass. None of us like to think about that, but we're all going to have to think about it eventually, and having those documents in place certainly makes it much easier for the loved ones that you leave behind.
Thank you so much, Todd. And like Todd said, be sure to check with your local attorney so you can get the right information when setting up your will and testament and your living will and fees. It is a small price to pay and definitely worth every penny. One thing I wanted to mention also was my parents had a will and testament in place. However, the documents were not processed properly, and my dad's name was showing on the deed but was never registered. Therefore, it cost us unnecessarily time and money in probate. So you just want to make sure that those documents are correct. At closing, about 30 to 60 days after closing, you will get your registered deed in the mail. Scammers are out there and they will try to tell you that you need to pay additional money for that registered deed, and that is not the case. You definitely want to check with your real estate agent or your local closing attorney for that information. That is something that you've already paid for at closing. One last thing I wanted to leave you with, and that is about 7 years ago, I created a sheet called Just In Case. I update it every year because just looking over it, I can already tell that there's things that need to be taken off or updated. And it's a basic information sheet for family members when we leave the girls with them and Chris and I travel on our own. I want them to know how they can proceed with making decisions if in the event something were to happen to us. So it's basic account information, information about our retirement funds, information about our life insurance policies, the girls' savings accounts. And in those bullet points, there is contact information, names, numbers, and addresses of who they can contact for those accounts, making it easier for them in the event that something were to happen to us. It's not a topic that we like to talk about, but I like to be prepared, and you should be too. You definitely don't want to wait until you're as old as that guy in the beginning to make these very important decisions for your family. So let your family members know what your wishes are. Sit down and talk to your spouse, your loved one, your significant other, and make that a goal for 2019 to get a living will and a will and testament in place. You will be glad you did. Thank you so much for watching. If you found the video helpful, please be sure to like and share.